We are going to be on the record in the matter of Robert Quint and Scott Rutkowski and Sarah Rutkowski, 22367, and appearance for the plaintiff.
Good morning, Your Honor. Julie Crota on behalf of the plaintiff.
Thank you. And Mr. Rutkowski?
Scott Rutkowski.
Thank you. And Sarah Rutkowski, please.
Sarah Rutkowski.
All right. And so then we have Robert Quint. Robert Quint, if you could please spell your name.
Spell your name.
And you say your name, please. Sorry.
State your name, Robert.
Robert Quint.
All right, thank you. All right, so on April 5th, the court held a hearing, and then the parties were to meet regarding actual amounts paid and what was actually still owed. So did that happen, Ms. Crota?
It did, Your Honor. I have quite a bit to say for the record, but basically we spent over 4 hours together, came to complete agreement on every single penny, came to an amount, and I wanted to sign a consent judgment, at which time Mr. Rutkowski said he wants his attorney to review everything, and he also wanted to take my work product to his attorney. So we ended up back at square one, Your Honor, after all the time that we spent on this and determined that they weren't represented by counsel. I'm in a very precarious position now of having phantom attorneys out there overseeing my work. But we did come to an agreement of a figure of $120,294.75. And I want to state that what that figure was based upon is that the Rutkowskis did not do what you asked to produce all of their paycheck stubs and things of that nature. But like I said, we sat down for 4 hours and went back and forth through items and came to an agreement on everything. They did produce a couple of checks that we didn't have. And I suspect that went back to when Mr. Kuzmiak had done the other forfeiture. So we straightened all that out. But we fixed the taxes, the insurance, the interest rates, the date of default, and everything else. There was a total meeting of the minds, and then there was a breakdown because he wanted to take my file to another attorney.
Okay, so just 1 moment. So the $120,294.75 is representative of the amount that's still owed by the defendants, correct?
That would be the redemptive amount if we sign a judgment right now. And we were also willing to put in there, Your Honor, the stipulation that Mr. Quint would allow them to list the property and sell it. So then we wouldn't run into problems with the title company again.
Okay, so Mr. Quint, Mr. Rutkowski, Ms. Rutkowski, please all raise your right hands.
Raise your right hand.
Do you solemnly swear from the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth? Mr. Quint?
Yes.
Mr. Rutkowski?
Yes, Your Honor.
Ms. Rutkowski?
Yes.
Okay, so Mr. Rutkowski, do you agree that the amount owed is $120,294.75?
It's close, Your Honor. On one of her figures, she had figured for 31 days of late payments. It should only be 19 months of late payments. She figured for 3 years when it was only should be figured for 2. But I mean, that's here or there.
How much was the late payment per month?
$75.
And you're saying that late fee should only be based upon 19 months, not 31 months?
Correct.
Was there discussion about that, Ms. Crota?
There wasn't, Your Honor, but I'll tell you what, I'm doing it right now.
Okay, thank
So,
you.
I know originally he asked me to adjust out 5 and I did. But we agreed
Right,
that the
but
date
you
of
would-
default.
Hold on. You cannot interrupt. Let her finish, please. Then you can.
Yeah, we agreed that the date of default was June 30th, 2019. So
And what did you want to say, Mr. Rakowski?
12.
What it is she had figured it for 3 years when it was only for 2 is to the end of the land contract, which was in 2021. So from 19 to 21 is when the late payment should have been figured, and she had figured to the end of 22.
No, I did not, Your Honor. He is absolutely wrong, and we discussed that. I took 31 months at $75 in late payments. And what that was for, Your Honor, was from the date of June 30th, 2019 till the date of January 1st, 2020. 2021. Anyway, oh wait, was it? Yeah, 2021, which was the balloon payment, Your Honor. That was the point of it. So I took it up to the balloon payment. Then once the balloon payment was done, I stopped adding in late fees and we went with interest only.
Yeah, if you add up those months, it's 19 months, not 31.
Let me see where I added late fees.
No, June 30th of 2019. Okay, well, starting in June of 2019, that's 1 month, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. 19 months is through December 2020. So
Yeah,
if you're
but,
going to January 1st of 21, that's 19 months.
but Your Honor, what it also included was the late fees for he was never current, Your Honor. So if we go back to the beginning, he was never current. So some of those
Okay, but
were
Council,
from
you
before. I
indicated
mean,
from June
technically,
30th of
we
19.
could have.
Council, you indicated June 30th of 19 through January 1st of 21 is how you computed the late fees.
Right,
that
but
would
then
be
there
for
were
19
additional
months.
ones from back. So what we had agreed on was 31 late fees. Even though if you look at the original document that I had provided to the court, he was never current since 2018.
Your Honor, when we had
So-
sat down with her at her office. Sorry, go ahead.
Yeah. No, go ahead.
When we had sat down at her office, we had came to the agreement that they weren't going to worry about those late fees to those other payments and stuff because there were miscalculations from the judgment in 19 that the checks didn't get put in to bring stuff current and that kind of stuff. So they said they weren't going to worry about the late fees or the interest on that stuff that was passed on that. So she said she would start from the last payment that we had made in June of 2019 and go from there.
Okay, is that accurate, Ms. Cronin?
Hold on one second, Your Honor. Okay, so we are now fighting over $900.
No, my question was, did that conversation occur?
What the conversation occurred is that we were waiving a substantial amount of interest. And the reason for that was the way that we went back to calculate was based upon an actual bank amortization schedule. And what the amortization schedule did.
Just one moment. Hold on, just a moment, please. Just a moment. My question is this. Mr. Rakowski is indicating that the redemptive amount is accurate, except for the difference in the late fees between 19 months and 31 months. And based upon your statement to the court that the late fees were based from June 30th of 19 through January 1st of 21, that would be 19 months. So my
Your Honor,
question
we
is this.
agreed.
Mr. Rakowski stated that you all agreed to begin the late fee calculation from June 30th of 19. So did that agreement occur when you all met?
We agreed on 31 months of late payments because the figure is right here in what I had, and it is the $2,325. The fact about the interest, what he's saying, I made it very clear that when we amortized out to get to the balloon payment, that there was no way for me as a human and not a calculator to go back in and add in the 7% interest on the missed payments. So the amortization schedule, Your Honor, I'm sure as you know, basically will say if you make all these payments at the time of your balloon, so much is paid towards principal. Well, those payments weren't made. So all we did was go back and add the missed payments. So that left a substantial amount of interest not calculated. So as we came forward with the late payments, was the same situation. There was a ton of things not added in a proper order. We agreed on 31 late payments in that amount. So he right now wants to fight over a difference of $900. I leave that up to Mr. Quint.
Counsel, please hold on. Please hold on, counsel. Mr. Rakowski, was
Yes,
there a
ma'am.
discussion regarding using 31 months because there was a waiver of interest?
Well, she had said 31 months starting from June of 2019. I have the conversation recorded, and I misunderstood. When I heard the conversation, I was like, 31 months doesn't add up for 2 years. So that's
Hold
when.
on, wait a minute.
Yes.
Wait a minute. Hold on.
Your Honor,
Hold on. First
Your
of all,
Honor.
hold on, please. Just one moment, counsel. Just one moment. First of all, Mr. Rakowski, you didn't answer my question. Was there a discussion regarding waiving interest and then utilizing 31 months of late payments? That was my question.
Yes.
Okay. Next, you indicated that you had it recorded. You recorded your meeting?
Without
The
my
last
knowledge,
part of
Your
it,
Honor.
yes.
Ms. Kruda, stop interrupting, please. I know how to handle this. Did you record that meeting?
The last part of the meeting, yes.
Did you inform anybody that you were recording it?
I had put my phone on the table and pressed record because I asked her to wait a second.
Sir,
Before, yes.
No. Listen to my question. Did you tell anybody that you were recording the meeting?
No.
Then what makes you think, sir, that you can record a meeting that you didn't tell anybody about?
I was unaware that I had to notify that I was going to record the last part of the conversation, going over the numbers
Then
just
if
so
you-
I could.
Sir,
Yes.
if you wanted to record the conversation, you didn't think there was a problem with it, then why didn't you bring that up before you started recording the conversation?
Well,
If you
I thought
truly
it was.
didn't think there was a problem, you would have brought it up and asked if anybody had a problem with it.
Okay, sorry, Your Honor.
You're not allowed to use that for anything. You recorded
Okay.
a confidential meeting without the consent of anybody. That is not permitted. So while 31 months was discussed and the dates of June 19th to January 21st don't add up to 31 months, that's what you're hanging that on, sir? Despite the fact that the late fees were calculated at 31 months and then some interest was waived?
Well, it was. I think when she mentioned the late fees, she said it was from June of 19 to the end of the land contract, which was January 1st, 2021. And when we were going through all the numbers, I was agreeing with them. And then when I reheard them myself, I was like, wait a minute, 31 months doesn't add up to 2 years because we had paid 5 months of those 2 years. So I figured for 19 months of late fees. That's all.
Would you agree that there were payments that you didn't make prior to June of 2019?
Yes.
Okay. And so would you agree that those months were total 31 months that you would have either paid late or not paid?
I wouldn't know off the top of my head.
If that number was the number that was being discussed in earnest in your meeting with Ms. Croda and Mr. Quint, would you agree with that amount?
Yes,
Would you also agree that there was a significant amount of interest that was waived in coming to your redemptive amount of $120,000, $120,294.75?
yes.
So why should this court not enter a judgment for that redemptive amount?
I don't understand the question.
Why should this court not enter a judgment with that redemptive amount?
Well, I mean, I agree with the amounts.
Okay, Ms. Rakowski, do you also agree with that redemptive amount?
Yes, I do.
Okay, so quite honestly, sir, we could have saved 10 minutes of your time when I asked if you agreed to that redemptive amount. And Mr.
Sorry, Your
Quaint,
Honor.
do you still agree, Mr. Quaint, that that's the redemptive amount? Whoops, I'm sorry, you're still muted.
Yes.
Yes.
Okay. All right, so therefore a judgment is going to enter. Is there anything else, Ms. Croda?
No, Your Honor, just that since less than 50% was paid, it'll be a 90-day redemption, and I will send the judgment into the court for entry.
All right, the court will indicate that judgment will enter in favor of Robert Quinn, the redemptive amount, $120,294.75 with the 90-day
Why did we let him sell it?
redemptive period. And Mr. Rakowski, you understand you do have the right to have legal representation, and you have chosen not to have legal representation.
Yes, Your Honor.
Ms. Rakowski, you also understand you have the right to have legal representation, and you have chosen not to have legal representation.
Yes.
All right. And counsel, anything else?
No, Your Honor, I'm satisfied. Thank you.
All right, thank you very much. And we will be off the record. And Ms. Croda, I hope that you're healing well. And then I will look for that judgment to sign.
Your Honor, thank you. That was very thoughtful. Thank you.
Off the record. Oh, we're already off the record. All right, just one moment.